Good afternoon, everybody. My name is Alexander Rufus Isaacs. I'm the interviewer for today's War Stories. War Stories is a series put on by the litigation section of the Beverly Hills Bar. We interview leading trial lawyers about one of their landmark cases, and today I'm absolutely delighted to welcome Gary Bostwick. Gary, good afternoon.
Good afternoon. Thank you very much. It's a pleasure to be here. It's an honor.
We like to think of War Stories as a combination of a case study where we learn, what it's like to try cases, how perhaps we can take some of those lessons and apply them in our own practices. And I think also we like to explore the autobiographical angle. It's always interesting to know more about the guy sitting at counsel's table and what took him there and all of the backstories behind one of these cases. Before I move on, I have to do a couple of housekeeping notes. First of all, you will receive your MCLE certificate shortly after the program by email. The certificate will be stored in BHBA Plus, which is our members-only community. Please take a moment to complete the survey that's included with your certificate. This program will be available in a couple of days in BHB On Demand, the BHBA newest member benefit presented by Lawyers Mutual Insurance Company. You should also have received by email a link to the materials for today's program. Gary has contributed a number of these, including a very good New York Times article, which is an excellent summary of the piece. We have a couple of the decisions in the case. And Gary's very distinguished bio. I'm going to break with tradition and leave it to you to read his bio. And I want to explore, Gary, before I go any further, I should say, if anybody has any questions, please feel free to put them in the chat function or the Q&A. I'll see them either way and we'll get to them. And I also should make an announcement that on September the 21st, the Beverly Hills Bar is holding its 10th annual litigation awards. We are honoring Matt Rosengart as Litigator of the Year, and we're also honoring Judge David Cowan, the presiding judge of the Civil Division of the LA Superior Court, who will be receiving the Ronald George Award for Judicial Excellence, and that's going to be a great evening. Emails have gone out, and information is on the website, and it's also in the chat function if you will see there. So with that said, on to the program. Gary.
Could I interrupt?
Of course you can.
Do you want to say something about the bad language that will be used?
You're quite right. I have to give a profanity warning. Gary's going to be using some very bad language in this program. This is not by choice. It, in fact, is the language from the taped interviews with the plaintiff in this case, Jeffrey Masson. And I gather that he used the F word on numerous occasions. Gary is going to be using the word frequently, not for gratuitous reasons, but because it's important for tactical reasons, which he will explain. I should add, if anybody will be offended by the use of the F word, they should probably sign off the program now. And otherwise, I think that pretty much covers it, doesn't it?
I think it does. All
right. Gary, tell us a little bit of your background. Where are you from and what were you like as a kid?
Well, I'm not sure I have the introspection to be able to accurately tell you what I was like, but I grew up mostly in Wyoming, and I graduated from high school there in 1958, a year ahead of a future vice president of the United States. And then I went on to Northwestern. Most of you will not remember that Sputnik went up just a little before I graduated. So there was money galore for any kind of person that wanted to go to study engineering, because we were suddenly in a space race. And I was good in physics and math, and I liked it. So I got a large scholarship to Northwestern University, and for the first time went east of Omaha in my life. and went to Evanston, Illinois, and spent 5 years there in a program that involved working at the same time as you were studying. And I worked at Ford Motor Company. And at Ford Motor Company, because I was a young hotshot from Northwestern, I got all sorts of interesting assignments. And one of them was I put together with 12 other people one night the prototype of a car that at that time we didn't have a name for. We sort of called it the Cardinal, but it turns out it was the Mustang. So I put together the very first Mustang. I wasn't given very important jobs because I wasn't that good at the mechanical space orientation. But at the end, we drove the first Mustang out of the shop and into the outdoors, and it was photographed, and the Mustang went on from there.
I see on your bio that there is a gap of 13 years between you graduating at Northwestern and you're getting your degree, a graduate School of Public Policy from Berkeley in 1976. So what were you doing in those 13 years?
The first thing was that I was in the Peace Corps. I happened to be listening on the night JFK floated the idea of the Peace Corps, and I just was listening coincidentally. And as soon as I heard what he planned to do and the agency he planned to start, I said, that's for me. And even though I got a job offer at Ford, which was very attractive, I joined the Peace Corps. And because I had a good deal of experience in Spanish, I was sent to a Spanish-speaking country. I went to Bolivia. If any of you have been to Bolivia, you will know what I'm saying, what I'm talking about when I tell you that living at 12,500 feet is a completely different kind of living. First of all, you better not drink too much alcohol the first 60 days you're there. I did one night and almost threw up on the ambassador's rug, I have to say. I avoided that, luckily, or my years in the Peace Corps probably would have been different. I taught engineering at a school called the Instituto Tecnológico Boliviano, and also worked in community development out on the Altiplano in the small villages, and helping them develop certain kinds of skills. One of the most interesting things that happened to me when I was doing that was we spent a whole day teaching these villagers how to build furniture for their school. And when it was over, I said, you're all set. You've got the tools, you've got the materials, you know how to do it. You're in great shape. And they said, we couldn't do this. And I said, what are you talking about? We just showed you how to do it. You did it. And he says, oh no, that you were here. You were here. We couldn't do it by ourselves. That was the first introduction I had to the sense of peasants, probably all over the world, but certainly in Bolivia and Peru, that they simply didn't have the wherewithal. It taught me a lot about life. Then from there, I went back to the United States and I was looking around at what to do. And Lyndon Johnson revoked the draft deferment for married people. So the next day I joined the Army. I had that. Where were you
stationed?
I was stationed in Germany, right on the border with East Germany. I was the battery commander of atomic delivery howitzers. And we were supposedly going to blast the oncoming Russians with atomic weapons. But my fear was that we'd be overrun far before we ever got them all put together.
What took you to Berkeley?
I found out that after I was in the Army, I went again to the Peace Corps in Panama, and then I went back to Germany and started a company with a friend of mine where we translated and edited technical publications for all over Europe. And at that point, I suddenly realized my GI Bill was going to run out, and I'd better apply somewhere for something. And I thought, well, I want to be the president of the United States. And so it would be good to have a law degree. I don't want to be a lawyer, but it would be good to have a law degree. But the degree that you really want is public policy, public administration. I applied to 3 different schools. I got in, and I called a friend of mine. I said, I got into Cornell. I'm on the waiting list at Harvard. I got into Berkeley. What do you think? He was a graduate of Cornell. He said, are you out of your mind? Of course you'll take Berkeley. I said, okay, I'll do that. So when I came home from the 3 years of just larking around in Europe, I drove across the country to Berkeley and started at the public policy school and mixed courses between law and public policy.
What was it that generated your enthusiasm for the law and made you decide that you wanted to become a lawyer?
I got a summer job at Legal Aid Society of Alameda County. And this is where the Wyoming background comes in a little bit, I think, because it's a very conservative place in a lot of ways. It's more conservative today than it was then. But one of the things that was clear in amongst everybody's psychology was, I can do this and I can make the world better. The cowboy movies of the 50s just inspired me no end. I wanted to have a gun. I wanted to shoot the bad guys. And Legal Aid Society was doing just that. They stopped the Grove Shafter Freeway from being extended for years. They sued unions, they sued the Air Force, they sued the post office for sex and race discrimination. Every time I get on a bus in Oakland and there's a woman driving, I cry because I was part of that. So that's part of what I suddenly said to myself, I don't think being president of the United States is really all that exciting compared to changing these lives. So.
And you clerked in New Orleans. What took you down there?
I got a call from the judge, actually. His clerk had just backed out on him for the next year. And his good friend, later on the Fifth Circuit, Alvin Rubin, walked in and said, I have a young man who applied to me, but I can't use him. I've already hired everybody, but I think he'd be a good replacement for the one you lost. And so I clerked for a wonderful man, had a lot to do with my life and my thoughts about the law. He had been an all-star football player at Tulane. He'd grown up in a small lumber town in Delo, Mississippi. And the first day I was there, he said to me, now, Gary, I hired you because you're smart, and I have to have smart people around me because I'm not that smart. So the fact is that you know that the law precludes certain things up to about 30% of the situations, and other things between the 70 and the 100% of the situations. But in between those spots, I have a lot of discretion. And I'm going to tell you, my job is to help that raggedy ass poor person anytime I can. And living and working with a man like that for a year was also extraordinarily formative.
With that sort of ethos and your background at the Alameda Clinic, it would appear that, logical that you would have gone into a more plaintiff-oriented part of the law, but you end up as a defense lawyer. How did that come about?
Well, Yes, you're ignoring something on the resume, I think. That is, I started as a plaintiff's lawyer. And my original cases were mostly as a plaintiff's lawyer. For instance, the way I met Janet Malcolm was that I took on a case of Jeffrey McDonald, the Green Beret, who has been in prison now for close to 50 years for killing his wife and 2 kids. The question I'm always asked, and I was asked the first time by my 12-year-old daughter, is, did he do that? And I said to him, I'll never know. I won't know for sure. But if I thought he did it, I wouldn't represent him. So I can tell you, I don't think he did. And I think the evidence was put together badly. And I think his case was wrong. And that's the only reason I'll represent him. And Joe McGinnis, a famous writer at the time, had written a book about him. And I sued Joe McGinnis, not for libel, because a convicted murderer has no reputation. I sued him for breach of contract and for fraud. And the breach of contract was because McGinnis had entered into an agreement with McDonald. That obviously garnered a lot of attention, and it took a lot of time. And I could spend hours telling stories from that case, but that's not what happened. What happened was that Janet Malcolm decided to write a book about that case. It's probably her most, I don't know, famous, but it's most quoted and most thought about book, The Journalist and the Murderer, which of course, Jeffrey McDonald hates that title. But nonetheless, she came out and interviewed me. I went to New York and she interviewed me more. And I found what I read many years later, that you really don't want to let her too close to you, because all of your foibles are going to be on the page. You know, the fact that I reached over and grabbed my wife's plate when she hadn't finished, when we were out to dinner, and finished her plate for her. There's nothing really wrong with that, but it does make you feel a little spied upon. She wrote that, and she told me at the time, she said, oh, you know, I've had my own troubles. This guy named Jeffrey Masson has sued me. We won in the district court, and it's now up in the Court of Appeal. So I think it'll be okay. And that's all we talked about the case. Then she wrote the book, The Journalist and the Murderer, the first few lines of which just caused incredible debate throughout the journalism industry.
What was the message that she was basically sending?
That everybody that writes anything about anybody is lying to their subject, because the subject believes they are going to be portrayed exactly in that rosy light that they believe they are. And in fact, no writer can do that or should do that. And the first few lines said something like, anyone who's not too stupid to know what's going on knows that all of us are con men. All of us who write this way are con men. And I cannot tell you the fights I got into in parties with people like Daniel Shore from public radio, because they were so angry that she said something like that.
I'd like to start turning now to the Masson case, and perhaps a good place to start, if I may, would be Janet's article. I'm going to put it up on the screen now. And I'm going to read the first paragraph and a half, because I think it, first of all, tells us something about Masson, and it tells us also, shows us what an amazing writer Janet is. So in the mid-70s, a young man named Jeffrey Masson began to appear at psychoanalytic congresses and to draw a certain perplexed attention to himself. He was an analyst in training at the Toronto Institute of Psychoanalysis, but he wasn't like the other analytical candidates one sees at congresses, quiet and serious and somewhat cowed-looking young psychiatrists who stand about together like shy plain girls at dances, talking to one another with exaggerated animation. Masson, to continue the metaphor, not only assiduously steered clear of the wallflowers, but was dancing with some of the most attractive and desirable partners at the ball, with well-known senior analysts such as Samuel Lipton, Brian Bird, the late Victor Chalef, and the greatest catch of all, Kurt Eisler of New York. Masson was lively, inquisitive, brash, and very talkative, anything but cowed. He was not a psychiatrist, but a Sanskritist. He'd become a tenured associate professor of Sanskrit at the University of Toronto at the age of 30. By 35, he was a full professor. And he gave off a sheen of the intellectual big time that even those who disliked him from the start were grudgingly impressed by. He was good looking in a boyish, dark, mildly Near Eastern way. The photographs of Masson that presently do appear in the Times, New York and Time make him look more exotic than he does in real life and a bit plump and spoiled. At the congresses, Masson would sometimes be accompanied by his wonderfully intelligent, thin, elegant, mockingly witty wife, Terry. She stood out from the wives of analysts as Masson stood out from his fellow candidates. Victor Chalef, in recalling his first meeting with the dazzling Massons at a congress of the International Psychoanalytic Association in Paris in 1973, spoke of them as if he was speaking of the young Scott and Zelda Fitzgerald. They were so beautiful, so brilliant, and so delicious. Does that basically give an accurate portrait of how Masson came across?
I think so, in so many different ways. Of course, when I was with him most of the time, there was an adversary relationship going on. He was trying to seduce me in the way he would try to seduce anybody he was talking to. It was one of his charms, one of his talents, that he was so interesting and so charming that he thought he could kind of talk his way and smile his way and intelligent his way out of almost anything. But he and I had a completely different kind of relationship because of the conflict, but it's a great, and that's a great start to the article because it shows precisely the kind of writing that she did that would flow back and forth between highly complicated intellectual concepts and very personal metaphors that just would knock you off your feet.
And that article is in the materials that everybody should have, and I really recommend you read it. It's wonderfully written. It's a little dense at times, but it shows you what an amazing talent Janet Malcolm was. It's also 25,000 words and 41 pages, and that's only the first section. And there was, in fact, another section. So the complete article was, both articles were published in the New Yorker, and both articles were then incorporated into a book, which was then published by Knopf, I think I'm right in saying. Now, Masson, I believe, took offense to many of the quotations in the article and in the book, and he filed a lawsuit. And what I'm going to put up on the screen now is a graphic map, for want of a better word, showing what an intricate history this case has. Can you give us a quick overview of the history and how and when you became involved?
Okay, look at the bottom left-hand corner of the graph, and you will see the letter A above a box there. That is the beginning in the Federal District Court in San Francisco. He filed a complaint. The complaint listed many statements that he said were defamatory. They were defamatory because they were quoting him wrong. that was assigned to Judge Lynch there in that court. And he decided on summary judgment that the three defendants, that is Janet Malcolm, the New Yorker magazine, and Knopf, were all not guilty of any of the libel. I don't remember exactly his reasoning at that point. It's not necessarily important now. I'm not in the case yet. And then move up to B. And if you move to B, you'll see that it went then to the Ninth Circuit. And on the Ninth Circuit, that's when I met Janet during that period. And that's what she was talking about. She said, you know, it's at the Ninth Circuit, and I think it's going to be okay. And then it goes up to the Ninth Circuit. Next decision is C. That's a slight change in the decision in box B, which said, yes, it was close enough, more or less. I'm really paraphrasing here. And Masson, by this time, on his fourth attorney, I think, Charlie Morgan had taken it, and the complaint had been whittled down because it was proven right away that most of the things that he had alleged weren't said, were all on tape, and Janet had all the tapes. So it went to the Supreme Court. That's box D at the top, and I attended there. I was asked to represent her at the Supreme Court. I said, I can't do that. I'm not a Supreme Court specialist, and I haven't been involved in this case, so that I'm not steeped in all of it. And without one of those two, you're better off with somebody else. And they said, well, will you help us as a consultant? So right up there at D in the Supreme Court case, I helped prepare the case for the Supreme Court. I attended the hearing. It was such a thrill. I walked out of there, as every time I walked into the Supreme Court and argued, I walked out and said, I don't want to do anything else the rest of my life except this. But who's that lucky? Well, there's a couple. Erwin Chemerinsky, for one. As you can see, then it went back down to the Ninth Circuit, and there Judge Kaczynski, Alex Kaczynski, did the decision, and it was decided, and this is very interesting for libel lawyers, that the publisher of the book had no actual malice. And the reason it didn't is because it relied upon, I believe the words were, the vaunted proofreading department of the New Yorker. And I can guarantee you, I, as a subject of her earlier book, had gone through all of that, and I know what he's talking about. They were rigorous. And so he said there's no evidence that the publisher had any inkling that there was anything wrong with the book. Nothing. They're out. Now there's only the New Yorker and Janet Malcolm. Janet Malcolm is in it because the Supreme Court said she is. And the reason they said she is because they came up with a new rule that had never been applied before, which was that if the quote varies substantially in terms of the total meaning, then it is a misquotation and it is libelous as such. So you can see right here, this highlighted part, petitioner took, I'm sorry, you're gonna have to go up.
There we go.
Petitioner took his abandoned family name as his middle name. We agree with the Court of Appeals that the words attributed to petitioner did not materially alter the meaning of his statement. those words at the very last line did not materially alter the meaning of his statement are the important ones in terms of the holding, because that's what this Supreme Court decision said. If you change the quotes around, move them around, shift them, leave out words, take out things. For instance, if you remove the words which Masson frequently spoke on the tape, when he would say, I don't know what they were thinking about when they decided that they were going to fire me. They didn't know what they were doing. Now, the New Yorker didn't publish that word ever. And therefore it all got taken out. And the question is does that materially alter the meaning of his statement? And that became important at trial sooner or later, which is why we warned you at the beginning about this. So you have there the crux of the case, and I was sitting in the audience. But when it came back to Kaczynski's, the hearing before Judge Kaczynski and the other two judges, I was there representing her.
There were a lot of the controversy, as I understand it, was over Janet's use of long statements that she attributed to Masson that she put in quotation marks. Correct?
Right.
And 6 of them went up to the US Supreme Court, and 5 of them they sent back down. Correct?
Right.
Were those the statements that ultimately ended up going to trial?
Yes. And is it possible to get them up there?
Let me see. Is that it? Wait a second.
Sorry to do that without warning.
Just coming in a second. Hang on. How's that?
Good. So here's all 6 quotes that were at issue in the Supreme Court. We're not going to go into all of them because it could take forever and it would be, frankly, wearing. But as you can see, the top one that I've highlighted there is really important because, again, that's the quote that he sued on. And in fact, if you read it, it's my father is a gem merchant who doesn't like to stay in any place too long, blah, blah, blah. My parents named me Jeffrey Lloyd Masson. But in 1975, I decided to change my middle name to Musayev. It sounded better. Well, we were never able to prove, and at the Supreme Court, no one was able to show that he said it sounded better. What he did say was, I liked it better. And that's why the Supreme Court said, that's why it was rejected by the Supreme Court, because it didn't fit their mantra, which was, does it materially alter the meaning of the quote that those words were changed? The rest of them all went to trial, both times. He had the wrong man. He was talking about a conversation with Kurt Eisler, where Eisler was trying to get him to just go along with his being fired, and maybe someday we might even hire you back, and it's the honorable thing to do. And Masson said, well, he had the wrong man. That and the other quotes, including I was like an intellectual gigolo, including I don't know why I put it in, talking about why he put something in an academic paper and he didn't know why he put it in. He objected to that. He definitely objected to sex, women, and fun. And that quote is a very short one. If I'd moved into the Freud house, the house would have not only been a place of scholarship, but it would also have been a place of sex, women, and fun. That provided a lot of grist for the trial, for me. the last one was the greatest analyst. And he said, he was quoted as saying, Farrar, Strauss, and Giroux had taken The Assault on Truth, his book. Wait till it reaches the bestseller list and watch how the analysts will crawl. They move whichever way the wind blows. They will want me back. They will say that Masson is a great scholar, a major analyst. After Freud, he's the greatest analyst who ever lived. Right. Now, you can see that, of course, Zan, you can see that her description of him in the article, just from those quotes, it was quite accurate. Now, the three of those quotes, there were no handwritten notes to show that she had taken those notes. She testified that she had taken those notes. We'll get to that later. Can I tell them a little bit about how Janet works?
Sure, please do.
As you all may know, I mean, Janet passed away just recently. But what she would do is she would only do approximately one typed page a day. She picked her subjects. The editors at the New Yorker were almost always happy with them. And she would just go after it. And she would write handwritten, and she would write enough to make up about one typed page. And the next day she would type it. She would keep both in almost all cases, except one that we'll talk about. And that is a slow, methodical sort of. She was, by the way, a daughter of a psychoanalyst from Czechoslovakia who had immigrated to the United States. So almost all of that family life had been imbued in her, and it showed when she did psychological subjects.
So, I mean, in this case, she had 40 or 50 hours of taped interviews with Masson, and she had all these untaped interviews when they were sitting in the car or when they were staying with each other or whatever. Was that normal for her to really go into such depth with the subjects?
Yes, always. I worked with her later after the trials, sometimes just advising her on some legal points. And every time she had, unless it was a short little piece, that was just fun.
So maybe we can turn to the trial now. We have about 20 minutes left, and maybe you can start talking us through, the trial process. There were two trials, were there not?
There were. I think sometimes in my own mind, the trials kind of mix all up together. But the fact is that the first trial, one of the things that I did was to have my son, who was a budding graphic artist, make a bunch of graphs, and it was before the day that you could actually use PowerPoints and things of that nature to any benefit. We played enormous numbers of excerpts from the tapes on a tape recorder, my own tape recorder. Actually, there was a system in the court. I didn't like it, so I used my own tape recorder, and I set it in front of the jury, and I would play the parts that we wanted them to hear. And part of what we wanted to do was for them to hear his intonation and to hear the fact that he used the word fuck over and over and over again, and that it never appeared anywhere in the New Yorker. They just didn't do that, nor in the book, right? So it was an important kind of subconscious training of the jury, the two different juries, in the fact that he was just exactly as she described him, brash. He didn't care about what people thought about what he said, and so forth. And so he was probably the last person that any normal juror would say he has a right to complain about whether he's misquoted. I mean, just quoting him is all you have to do. And he's not going to look good. And what had happened though on the first trial, and I'll skip over most of that, I think, because I showed at one point what Masson's prospects were when the article came out. And I showed him with his holding his pants pockets out in the old Depression meme of people who have no money, right? And the reason I tell you that is because they hung on damages. They actually found, in terms of what the defamatory meaning and whether she meant it and whether she violated the rules of the Supreme Court had set down, they found against her in most cases, actually. But on damages, they completely hung, and they, no matter what happened, no matter what Judge Lynch did with his warnings and his so forth, you know, he couldn't convince them to keep going further. They came back, it was a hung jury. We had to have a new trial. One of the jurors came up to me afterwards. He said, "I saw that poster you put up in front of us where he had no money whatsoever. And I thought, this is a money grabbing intellectual who's trying to con the system. I wasn't going to give him a dime."
Where was the trial located?
Pardon?
Which city was the trial in?
San Francisco, in the federal court, in the main federal courthouse. And both times. So Judge Lynch said there's going to be in the second trial. Now, again, Zan, I can't tell you whether this happened in the first trial or the second trial. But what I was trying to explain to them is that it wasn't wrong to be moving things around and out of order and not in the exact narrative that the subject who you're writing about, you're not just a bullhorn where you're letting him talk into your book. What you're doing is you're trying to write about him. And therefore, it wasn't necessary to let him say his words exactly in the order that he said them. I had these four, I had STORY, that spells story, right? I got five children's blocks, and I had story on them. But when I put them up in front of the jurors, it made no sense because I had not turned the sides to them that they could see the word story. And I said, this is what Janet Malcolm does. She takes this part of the quote and she puts it here. And she takes that part of the quote and she puts it there. And then she takes the other one and she puts it here. And when she moves this last one into place, voila, story. But otherwise, it's just gobbledygook. That was one of the things that had a big effect when we talked to the jurors afterwards. Another one was to talk about actual malice. For those who don't do libel, it's hard to realize how important and how evanescent actual malice is. I mean, what does it mean to have reckless disregard of the truth? We all know what it means is you didn't tell the truth. That part of actual malice is clear. But reckless disregard of the truth, what does that mean? Driving too fast? What does that mean? And so what I said to the jury at one point, I said to them, this is what actual malice is. Actual malice is, here I am, I'm looking at you, and I see some true information, and I have every reason to believe it's true. Then I turned my back on them and walked across the courtroom, kept talking, and said, but the person who has actual malice who's already seen something that he thinks may be true or she thinks may be true as I was walking, and just ignores what they just saw. Then I turned around and said, that's actual malice. Now, I don't know if that's any good or not. I just know that it seemed for these jurors, it worked. And so we came out with a verdict that was very much in her favor. And Masson was a very good witness because he's quick, but he has the problem of not in fact basing everything he says on facts, but on things that he imagines are happening. And I recognize that from our depositions and everything else. And at one point about the sex, women, and fun quote, I said, well, you complain about the fact that she says that you were going to turn the Freud house into a place of sex, women, and fun. Wasn't there going to be sex there? And he said, what do you mean, Mr. Bostwick? And I said, you were going to live there with your girlfriend. Were you going to be celibate? Going to give up sex? You were going to bring sex to the Freud house, right? And another place you say you're going to have big parties. Lots of people are coming. Sex, women, and fun, right? I mean, how's that a misquote? When in fact, that's exactly what you had in mind, that sort of thing. So it was not difficult in many cases to kind of pin him down. One of the things that happened towards the end of the second trial that was a problem was that they said, you don't have the handwritten notes for 3 of those quotes. And we searched and searched and searched, and we couldn't find them. And Janet had the typewritten notes like she had already done, but in that one case of those 3 very important quotes, she didn't have the handwritten notes anymore. And about 8 months after the verdict, her 2-year-old granddaughter in their house in Connecticut was looking through the library and found a beautiful little book, pulled the book out, opened it up, and out fell the handwritten notes of those 3 quotes. Anthony Lewis, the author of Make No Law, tremendous reporter, great mind. He wrote a column in the New York Times, I think, telling all about the granddaughter.
Maybe I can put up the verdict form and you can talk us through that.
Okay, that's a good one.
Here is the special verdict form, November 2nd, 1994.
Now, those of you who have any technical background, I mean, you may have some questions, Ann, I don't know.
I'm sorry?
Do you have any questions about this you're really interested in?
I think did you think that you were going to win on intellectual gigolo? Because intellectual gigolo was not a phrase that I think he actually used to Janet. Isn't that correct? That this is something that she came up with, that it wasn't a direct quote?
No, I think that one is a direct quote. I may be wrong. It's a long time ago, but I think that one was that he used those 2 words. But I'm not sure. Can't remember. But this is sort of like a filtration tank, and for libel lawyers, it's common. And first, were any of them false? It's going to have to pass that test.
Yeah.
And they said, the jury said, sex, women, and fun, that was not a misquote. That wasn't false. To have him say that. Intellectual gigolo was not false. Greatest analyst was not false. But he had the wrong man. And I don't know why I put it in. Those were false. Okay, now let's go to the next level of this filtration tank. Well, okay, if they were false, were they defamatory? I don't know why I put it in. It's not defamatory. Now, if you think about that for a while, it's really common sense. I mean, who cares whether he said it was important because he was an academic, and that he would put in something without thinking carefully about it was a big deal, right? And the jurors, not being of his ilk, sort of said, I don't get that. And they found that not defamatory. And then we had the problem with the wrong man. And that always had been a problem. And when it came down to it, when you go to the next level of the filtration tank, did she act with reckless disregard? Did she turn her back on the truth when she used those words? And the answer is the jury gave was no. That was a tough one, I have to say. And one of the reasons is that it is very harmful to him that he is saying that he's, if he didn't say they had the wrong man when they tried to bribe me, essentially. And Janet was convincing the second time in showing that she had written it down and that she believed that's what he meant.
I mean, it's consistent in a way, is it not, with the what Mason was saying, which is he just wasn't willing to sort of shut up and suck it up, and that
Right.
He was going to make a fuss about it. And if that was the message that he was conveying to her in their interviews, she is perhaps paraphrasing it, but she's not willfully misstating it. Would you agree?
I agree. I mean, that's certainly what I argued. And one of the interesting things between the two trials, Zan, was that in the first trial, Janet came, as she always did, dressed more or less in very mousy attire. I mean, she just didn't dress up. She didn't go to the New Yorker office dressed up. She didn't go to parties dressed up. I went to dinner with her with famous authors. She wasn't dressed up. And she always would, when she was reading, she would then put her glasses down, and then she would put them up. She looked like a schoolmarm, right? And I said to her, could we lighten this up a little bit somehow? I mean, and she said, no, I don't want to try to be somebody I'm not. The second trial, she showed up the first day with an olive green dress and no glasses on her head. The next day, it was rose pink. I'm telling you, she got religion between the two trials about what you wear.
And are there any other differences that you can think of between the first trial and the second trial? How it was that, you got the very different results in both of these trials? Was there any difference in your approach? Was there any difference in opposing counsel's approach? Was there anything about the jury that struck you as different, or was any of the evidence different?
The evidence was not essentially different, but it was presented in a different way. I certainly improved. If you don't learn from what happened before, you're making a big mistake, it seems to me. I don't remember exactly how I changed things between the first trial and second trial. It's too long ago, I think. But I do remember that I focused much, much more on the jury verdict of the first trial and why it had come out the way it did. I knew that the psychology of the second jury wasn't going to be identical. And I did think that we picked a better jury the second time. Both times we picked a jury on a jury questionnaire, but I thought it was a better jury the second time, and I felt happier with it. And I do know that I did alter my approach in so many different ways, simply based upon the cues I'd been given by the jury in the first trial.
For example, did you use the children's, the blocks in both trials?
I don't think I did. I think I actually used them in the second trial.
So the message from today's program is use building blocks. Or visual aids as such, is that part of your sort of trial strategy? Is it a part of a sort of teaching and a demonstrative way to give people things to look at? Do you like doing that?
I do. I have been a teacher all my life, and I try to make sure that the questioning is something that the observers on the jury, when they see it, will have a moment where they say, oh, I see what he's getting at. I try to make sure I'm not just getting evidence in, but I'm making a point by the way I'm asking it, and hopefully the answers I get back. Because if you don't realize that you have to teach the jury, and it's complicated, and it's not something they're used to, if you don't, I sometimes design my cases on as if my mother were sitting in the jury, because my mother had no education. She had been born in Arkansas. She'd traveled to Oklahoma, and she'd pick cotton on her knees. That's the person I would almost always try the case to.
Going back to the special verdict form, well, let me ask you about this. This is a quote here, which I rather like, from the New York Times article, where a couple of jurors are talking. One juror said the verdict finally had a lot to do with him, in other words, Masson running his mouth off, and another said Masson was too honest. He opened himself up and he just showed his true colors. She painted him and he didn't like it. Do you agree with that?
Yes, and I thought that was extraordinarily literate. I don't remember which one said it, because I don't place the name with the face anymore. But it's very clear that person got it. You know, you just wanted to talk to somebody, and you did, and you talked, and you talked, and you talked, and she just painted you the way you talked. You can't complain about that.
The second trial resulted in essentially in a defense verdict, correct?
Right. Oh,
because
by the way,
ultimately,
no, I'm sorry. I don't want to mislead everybody. The New Yorker got out of the first trial. They weren't in we were alone in the first trial. In the first trial, I said to the New Yorker lawyers, you guys sit down at the end of that table down, our table. You sit at that end. We're going to sit at this end. And the lawyer, who was a wonderful person, said, Gary, aren't we all in this together? And I said, not starting today. And they got out and we didn't.
Yeah. I'm looking again at the special verdict form. So we end up with two statements that are found to be false. Only one of those is found to be defamatory, and of that, there is no actual malice, and everyone conceded that Masson was a public figure. So that is the basic for the defense verdict, correct?
Right.
Did Masson appeal?
He did. And
did anything happen on the appeal?
In terms of what we're talking about, no, but several things happened. Number one, Judge Kaczynski wasn't part of that panel, as I recall. But I may be wrong about that. But also, all during the trial, he had flaunted his relationship with one of the most well-known feminists of the day, a professor named Catherine McKinnon. And she was appearing at trials. She was at the counsel table when we were waiting for the jury to come back and so forth. And by the time the last appeal went, the last I saw of the two of them talking, she had come to see the ceremony. And then she said, okay, well, we'll see one another sometime, and walked off down the hall. And I said to myself, this is the price I think that some people have to pay, because I don't know how a relationship could stand that constant litigation going on.
I mean, if we, just consider the, extraordinary history of this case, with all of those hearings, with all of the appeals, with 2 trials, I mean, this must have taken a tremendous toll on both of the main litigants, did it not?
I think it did in lots of ways. But Masson became a successful author. He wrote books like Why Elephants Cry and Why Penguins Make the Best Parents, and all sorts of other things. And he went off to New Zealand. He didn't seem to suffer that much one way or the other. He certainly had to pay costs, but he was not a broken man by this. And Janet just kept moving, and she was pretty defiant about, I'm not going to change the way I do this.
We're pretty much coming to the end of our time. Is there anything any overall impressions, anything you'd like to share with us?
No, except for those people who haven't actually had the challenge and the experience of being in the middle of presenting a trial in front of a jury. I can only say, if that's what you want to do, you're right to want to do it. It is one of the most exciting things. It was almost as exciting as playing for the state championship baseball championship in Wyoming when I was 17, and Dick Cheney was playing third base.
God bless you both. That is it. We've answered the questions, and so we are out of time. Gary, I want to thank you very much indeed, and I also want to do a shout out to Kelly Sager, who actually originally suggested we do this. I'm really glad she did. And if anybody out there has suggestions for any other subjects for war stories, we would love to hear from you. And with that, it only remains for me to thank Gary very much indeed for being extremely patient with me. And I've had a fabulous time spending time with you and learning about the case and more about you. And for me, it's been a great experience. So thank you very much indeed.
I enjoyed it very, very much. And I thank you for the opportunity. I really do.
Okay. Thank you very much, everybody. Thanks for attending.